Hi guys, it's Kathy. I hope you're doing well. They updated my software. All the audio is way different. Chances of me muting myself, super high. Higher than the Empire State. Not higher than Martha right now, I hope. Martha, I hope. Okay. We got a few little clips today we're going to watch, and then we're going to watch some Judge Fleischer. Yes, sir. We did see this guy. We saw this guy once before for his initial hearing, and now he's back for his sentence. He went he was in work release. He went to the hospital. While he was at the hospital, he was waiting on tests or the doctor or something. He walked across the street, got a pack of cigarettes. Hi, Martha. Bill, I just want you to know. I tried to make my background your logo. It wouldn't show up for some reason. It stuck on the old background and wouldn't switch over to your logo. Oh my God, Bren is here. Bren, you're supposed to be working. I know it's Sunday, but that doesn't mean anything. All right. So this guy walked across the street, bought a pack of cigarettes and a soda. I didn't say that before. That's important. You guys are going to call me a liar now. I'm just very forgetful. Here we go.
Okay. Are we ready for census today, sir?
Yes, we are prepared for census.
Good. Did Mr. Borkowski have an opportunity to review the PSI, Mr. Kozlowski?
He did, and he has a copy of it right there to take with him.
Very good. Were there any errors or corrections that need to be made in that document?
Not that I saw.
Yeah. All right. Are there any victims or witnesses to testify from your side?
Yeah.
No, you're not.
I'm sorry you're sick. Should we guess what he has? He said he was tested for that, so it's probably not that.
Then do we agree that we have 168 days of Class B credit?
That is what we have on the credited to him on the newer case.
Right. And then addressing credit on the other causes, 0813. Are we looking at about 59 days? Is that what I saw?
Correct, and that was from previous to this violation, I believe.
Okay. And on 822, 185 days of Class A?
Yes, Your Honor.
Okay.
I think that's correct.
Great. Mr. Kozlowski, when you said previous to this violation, was there additional credit time you think that was?
No, I was just meaning to say he was not serving that time while he was here this time. That's all I was trying to.
Okay, I just want to move through. We're not missing anything. Right. Gentlemen. That's very good. Burn some time. We'll make sure you get it. Okay. So, Mr. Borkowski, what we're going to do is we're going to hear from your attorney. He'll make his argument recommendations, and we'll hear the state. You'll have an opportunity to speak again as you'd like to. Okay. Mr. Kozlowski, the floor is yours, sir.
Your Honor, on the face of it, probation recommendation on the SB case for the escape, it may seem to make sense. I think if you look at my client's history, just purely at the numbers, you might look through it and you say, sure, that makes sense, send him away. But here, I think we get into a problem that one of my law professors that had a big impact on me, Joseph Hoffman, down at IU, once talked about in class, and that's kind of the quicksand problem our criminal justice system creates for defendants here. It's very easy for politicians to simply say, I'm tough on crime, let's keep increasing the penalties, et cetera, et cetera. Here now we have a situation where we have an elevated escape charge for level 5 after he had been sentenced on a 6. So not only is he going to be punished for the placement violation, but then also now a level 5 felony on top of that. This is creating a situation where, we are making the state just a hammer. So everything has to be a nail. So of course, under that scenario, my client should be getting more time if that's how we're looking at things. I would draw the court's attention, though, to the probable cause update, because I think the facts in this case say a lot about kind of what my client might deserve. The court wants to look at it that way. This case, he was at Duke Center through the work
Hi,
release
Ronnie.
program and
Kelly, what was your son's name? Is that what you're struggling with tonight?
was at Memorial Hospital. While he was at Memorial Hospital, he went across the street and was getting something. They picked him up immediately. Immediately. He wasn't gone in the wind. He wasn't running. He walked away from the hospital, walked across the street. He understands that that's a violation of the law, and he admitted to that. What I'm trying to convey to the court is I think that he has paid his penance on this particular case in terms of executed time. As I said, if you look at the numbers and his convictions, it's very easy to look at Mr. Borkowski and say, let's just send him away. And as I told him, I think that the court could very well find that that's the appropriate response. But our tactic here is to throw ourselves on the mercy of the court and say, Your Honor, the facts of this case are not the most egregious thing that we have seen. In fact, I would say this is approaching a de minimis, the de minimis version of an escape. He has been sitting in there for over 6 months, and he has patiently awaited a resolution on this case, knowing that he's probably going to get some executed time. I believe with the credit time, if Your Honor were to order it to go to the placement violation, I think he will have satisfied his sentence if I am counting correctly, and he would still have some time on this case. I would ask Your Honor to allow my client to be released and go on to probation on the escape charge. That's not a request I normally make lightly. When you're facing an escape, you have already violated community corrections, a more restrictive option. However, I think given this case and what the allegations are in this case, I don't think that sort of thinking necessarily makes sense. If my client is to violate probation here, he understands that he's gone.
Yeah, that's fair.
And he's probably going to go away for a substantial amount of time. I would just ask the court to allow him to serve probation to try to get his life back on track, because if the court sends him for 3 years, he's just going to be leaving prison with nothing in his pocket, no family support, nothing 3 years from now or 2 years from now-ish. And, he's going to be in the same position he is now. At least if we say, okay, you've paid your debt to society, the punitive part of this is over, let's try to get things right now. Maybe then we won't be seeing Mr. Borkowski. And I can't say that if Your Honor does that, we definitely won't see Mr. Borkowski. But we need to at least have a breaking point where we are not just thinking
That lawyer got me convinced too. You're right.
about retribution here. We are thinking about what we can do to allow people to try to get their lives back. And, Mr. Borkowski has been living kind of a wild life for some time now. And whether or not he's done with that, I think he is, based on my conversations with him. But
he told
we
you
won't
so.
know unless we give
Got
him a
it.
chance, Your Honor. So I'm just asking Your Honor to apply the credit time that you can to his placement violation, and then whatever remaining credit time to this case, and allow him to serve a term of probation with potentially a lengthy suspended sentence hanging over his head so he can try to make it. We talked about possibility of just asking for a straight executed sentence and just sending him on his way. If he had more credit time, I think that would make sense. But, that is also an option. But my client's preference at this point is to try to receive some services and try his best to try to build his life back here. Thank you.
Thank you, sir. State.
Yes, Your Honor, I think the state's going to be in a pretty different place. Interestingly enough, apparently Mr. Kozlowski and I both had the same professor that we really enjoyed down at Maurer. What I'm going to say is going to be a little bit different. What we heard Mr. Kozlowski say is, please give him a chance. Maybe something will change. What we're actually looking at when we look at his criminal history is 22 priors, 15 misdemeanors, 7 prior felonies. He's been revoked from probation 3 separate times, and that's not counting where we are now. The criminal history extends probably about as long as that I've been alive. So to say that he has not been given chances is a complete misread of his entire criminal history. There have been chances over and over and over again, and he has wasted every single one. Looking at his PSI, there are basically no mitigators. He had a good childhood. He's got no high school diploma, no GED. He's unemployed, and it doesn't look like that has changed in the history of his contact with the law. That is where let's try something different doesn't make sense, because there's nothing to point to that things would actually change, that something would actually be meaningfully different. He accepted responsibility. That is the only mitigator that the state sees. The aggravators, however, are the criminal history, being on community corrections for 2 separate offenses at the time of this offense. And while it might be a less meaningful resist and run away, he knew what the rules were. He knew what the stakes were for his own freedom, and he still chose to disregard the placement that he had, the rules that existed, and he knew better. Looking at his criminal history, it's very clear that he knew better and just chose to disregard. So for the state, probation's not a good fit. MCC won't take him. The only option is the Department of Corrections. So that is the state's request for F5 278, 3 years to the DOC. On F6 822 and CM 813, doing the back of time for the DOC as well.
Hi, Tanner. Your mom rocks. She's very cool.
Borkowski, anything you want to say, sir?
I made a mistake. I went to the hospital. I went to the gas station. If I had known it was going to be this extreme instead of out of place, if I got caught, I would have never done it. I was going to get something while I was waiting my turn. I didn't know dudes going to follow me and had me arrested. Why they just didn't pull up on me and hit me for being out of place, I ain't got a clue. I'm trying to get my life back.
He escaped for 5 minutes. He was at the hospital. He walked across the street to the gas station and bought a pack of cigarettes and a soda.
I buried a kid. I've been through hell. I ain't gonna lie. I've been through a lot that most people ain't never even been through. I'm surprised I'm even still alive myself. Do I think Department of Corrections is the right place for me? No, because there's no rehabilitation. I wasn't trying to escape from Duke. I was just going to get some cigarettes and something while I was waiting my turn to get seen at the hospital, because Duke don't allow you to take your stuff with you when you're going there. And I'm supposed to contact them every hour. I never even had the chance to even go back to even contact them within the 2-hour time span that I was supposed to have. They had me arrested 20 minutes later. So how did I escape when I never had the opportunity to go back?
Dude, your lawyer did such a good job, and you were like, yeah, I knew it was wrong, but I didn't think I was going to get in this much trouble. Idiot. Shut up. Stop talking. Lisi, thank you for 20 months. Thank you. That is amazing.
They never gave me the opportunity. If they followed me to the gas station, why didn't they come to me and say, hey, what are you doing here? You're out of place. You're supposed to be over here.
They're not your mama.
I don't understand that. But I've seen him do that with so many different things. You know what I'm saying? I'm not saying what I did was right.
They could have made other choices. You could have made.
We both could have made other choices. You're exactly right, Your Honor.
Okay. Anything else, sir?
No.
Okay. Well, I appreciate you. And I don't think either of the attorneys are wrong in this matter. Probation, community corrections, not good options for you, because you demonstrated that you kind of want to do what you want to do. And for the most part, that's okay. If you weren't under supervision, walking across the street to the gas station, get some smokes and a soda, it's not a big deal. But you knew that was against the rules, and you waited out. What you said today, it means you waited out. Like, wow, worst thing that happens is I get like violation, and they pull the plug on you. Well, bummer, man, but you chose that. Mr. Kozlowski said that the criminal justice system creates the states. You stepped right in it. You opened the door and walked right in. But here's the deal, though. He's also right that as far as an escape goes, that's about the weakest escape ever. It's pretty soft. And you didn't fight. You didn't run.
No.
You said, well, okay, here I am.
You know what I mean?
And for that, I respect that a lot.
Bill, thank you so much. I really appreciate it.
You made an admission when you got here. You pled. You accepted responsibility. You have stood back to yourself and said, look, you're going to do what you're going to do. I get it. But I do appreciate that. So here's the thing. As far as the ledger sheet goes, I'm considering all the aggravators and mitigators. Your criminal history is a huge knock against you. The fact that you got revocations and violations of probation and violations of community corrections, all of it's just really bad. On the flip side, the things I just mentioned, you did accept responsibility and it's an innocuous version of an escape. So the aggravators do outweigh the mitigators in that I think the sentences on these things have to be and will be conserved consecutively. The advisory sentence for that level 5 is 3 years.
Yeah, Judge, put them in jail. They were supposed to not let them leave. They're the ones that are criminals. Good night, Venus.
So starting at 278, that level 5 escape, the minimum is 1 year all the way up to 6, with the advisory sentence being 3 years, and that's what probation recommends. Given the nature of that offense, you need to be 1 year, execute. Department of Corrections got 168 days of Class B credit. That's a substantial chunk out of that. That's the bare minimum on that count. Because it wasn't the worst version of that I've seen. You didn't fight, you didn't run, you handled like a gentleman at that point. You made a bad choice. That bad choice is where it comes into play on 813, the petition to revoke. You got 59 days of credit on towards a 1 year sentence. That sentence you're going to have to serve backup time. Then in clause number 822, that petition to revoke on towards a 2 year sentence, you've got 185 days of Class A credit. You're going to have to serve that backup time. So the violations get you backup time, but on the new case, I was as nice to you as I could have been, considering the fact that you were a gentleman. You're not going to have probation. The fresh start that you were looking for is you're going to get out and you are going to be free of any obligations to us. There's parole and there's parole, and that's between you and them, but you don't owe us anything after that. We'll be done and done. You got a good bit of credit time towards each of those sentences. It's not that much left. Under the circumstances, that's as kind as I can be, and I feel that some of that is warranted because you've been a gentleman handling, and that really is your mitigating circumstance. There is, as we mentioned, is your acceptance of responsibility and handling it well at the time. Anything further?
There you go.
All gentleman is indigent for all fine support costs and public defender fees. There's no probation or probation fees associated with this sentence. You're getting a fresh start when you get out, Mr. Borkowski. Don't waste it, sir.
You're buffering. Too much information. So that was the best thing for that guy, seriously. He's not going to be on probation afterwards. He'll be on parole, but not probation. Hi, doctor. So he gets out of jail, and he's done. He's done. I mean, stretching it out, he's just going to violate more and get more time put on top of that, But he got 3 years because they had to be consecutive. All of them had to be consecutive. But he had 168 days of credit, 56 days of credit, I think another 100 days of credit, so he has like 2 years left. He'll get day for day for that. So he has 1 year left. Let's move to, it's my mom's fault. It's just my mom's fault. This one might actually be his mom's fault.
Lavinia versus Marquise Grayson Reed, 406004 2311 CM 3115. What's your address, sir?
I don't have an address. I'm at the work release right now.
If you're new here, this is Magistrate John Link. So good. This man is, when he is on form, he is terrifying. And like he will yell something at you. Something short, like, why didn't you do what I told you to do? And his voice booms. And then he'll just sit and stare at you until you get an answer. But if you try to talk, he's gonna throat slam you. But he stares at you and waits for you to talk. It's bad. He's not gonna do that today. It's just, it's very intense. But when he gets there, whew,
So does your mail go to the work release center or where's it going?
Work release.
What quarters you sentenced to work release out of?
I think Superior Court 4. I think. I'm not sure.
Are you on GPS or are you in work release?
I was on GPS, but I didn't have nowhere to go, Your Honor, so I've been on work release for almost 3 weeks now.
So why'd you miss court?
Cause my mom, I get a Social Security check every month, and my mom's my payee, and I told her that I had to pay restitution on the 13th, and she said she was gonna pay it. I don't know why she was acting weird, and she didn't. She talking about she want to pay it now, but I was like, it's too late because they arrested me yesterday. But I didn't have no control over that though. I was in work release, but I would have paid it if I had my own money. She said she's gonna pay it though. That's what she told me yesterday. She's weird.
So how are you gonna get this paid?
I still have money and stuff. She said she's gonna come up here and pay it. She thought I was lying or something. Thought I was trying to get extra money out of her or something like that, and I wasn't. And she told me yesterday when I called her on the tablet she was gonna pay it because now she see that I got locked up. It's her fault. I have on my life, Your Honor. I had nothing to do with that. Like she's my payee. She's in control of all my money.
So how come you didn't come to court and explain that to Judge Friedman
Because they have. Oh, sorry.
on the 13th?
Because they haven't gave me no passes yet. Like my passes to go job searching.
They have to give you a pass to come to court.
Yeah, but
Did they know about your court date?
my case manager did, but my mom and her talks every day. She said my mom told her that she was gonna come up here and pay it, and she was just late or whatever.
How much is your payment a month?
Oh, well, how much I get for my check?
Yes.
Like $900, like $940, I think, a month.
So how are you gonna get this taken care of?
As soon as possible, Your Honor. I won't let myself down, you down. And she know this is very serious. Like I got into it with her yesterday about it. Cause it's literally her fault, like for real. I was at work release doing good and everything. I haven't been drinking, nothing. But I promise I'll get it paid as soon as I get out of here.
All right, Mr. Grayson Reed, I'm gonna OR you back to work release.
Yes, sir.
However, they're gonna have to come and pick you up from the jail, so that may not take place until tomorrow.
Oh, that's fine. I appreciate it. It's $45, right, Your Honor?
No, you owe $231.
$231?
Correct. That's your fine, your cost, and the $40 restitution you owe.
Oh, okay, so I just pay at the clerk's office, right?
Correct.
All right, that'll get paid. I got
Hold
you.
on. You have until March 30th, 2026 at 9 a.m. to pay that.
Yes.
If any of that is unpaid or partially paid, you are ordered to appear in court in person in front of Judge Friedman on March 30th, 2026 at 9 a.m., which is 2 weeks from yesterday, Monday morning.
Yes, sir.
If you fail to appear I'm not gonna do this again, and I doubt Judge Friedman will let you out again, so.
Yes, sir. Thank you for the chance. I promise I won't let you down, Your Honor.
All right, get this taken care of, please. You're excused.
Judge
Yes, sir. Have a
Friedman
good day.
would have given him a
Thank you.
chance. Man. Man, thank you so much. I really appreciate it. I really do. You rock. All right. Let's go with some young kids, man. Kids these days.
State of Indiana versus Kevon Sloan. The record should reflect the defendant appears in the custody of the Montgomery County Jail by video. The state appears by Deputy Prosecutor Greg Miller. The Public Defender's Office is present by Chief Deputy Public Defender John Dreyer. They've not been appointed to represent you with respect to any pending charges which might be filed, but he is here to assist you with this detention hearing. The purpose of today's hearing is to determine whether you should be released with conditions or held pending the posting of your bond. Do you understand the purpose of today's proceedings, sir?
Yes, ma'am.
Has counsel both received the pretrial services report?
Yes, Your Honor. Yes, Your Honor.
State?
Your Honor, the state is requesting that Mr. Sloan be held to bond. Our rationale is while he has no previous FTA history, no violations of pretrial supervision, he has burglary convictions as a juvenile. As an adult, he has a Texas conviction for aggravated robbery with a sentence of 6 years probation. It scores moderately on IRS. For those reasons, we ask that he be held to bond.
Thank you, Mr. Dreyer.
Your Honor, I don't have any disagreement with Mr. Miller other than the fact of holding this young man to bond. It does appear from the report from probation that he was on probation out of Texas. He does not have a very lengthy criminal history, and as Mr. Miller stated, he has no history of failures to appear or pretrial supervision violations. And his score on IRAS is only as moderate. As the court to release him, I would like to ask him a question, if I may, please.
You'd raise your right hand, sir, to be sworn. We'll take some evidence from you. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Put your hand down. Please state your name again for the record.
Kevon Sloan.
Yvonne Salome.
Thanks, Your Honor. Mr. Sloan, if or when you are released from our jail, would you return to Houston?
Will I return to Houston?
Yeah.
Yes, sir.
And would you pledge to attend all future hearings in this matter?
I couldn't understand you.
Will you attend all future hearings in this matter?
Yes, sir.
And how would you get up here from Houston?
I will have my mom bring me in the car.
Okay, your mother has transportation?
Yes, sir.
Thank you, Kelly. Thank you.
And you live with your mother?
Yes, sir.
Her name's Tawana?
Yes, sir.
No other questions?
The court will note that Mr. Sloan has zero contacts with Indiana or Montgomery County. That he is currently on probation for an aggravated robbery out of the state of Texas. That the allegations are that he, with 3 other young men, attempted to rob an ATM here in Crawfordsville at one of our banks, causing a significant amount of damage.
Notice how she said attempted. I don't think she said attempted because they pled down to attempt. Those things are freaking hard to rob. Might I suggest never try to rob an ATM. Set your sights on other things. They're just way too difficult. Just my advice. Don't rob ATMs.
That he scores moderately on the IRAS assessment. That he has a prior adjudication for burglary. Although he doesn't have an extensive criminal record, he's also only 22 years old. Court will place a 15-day hold on you, Mr. Sloan, to see if Texas is planning to file anything to bring you back to face a probation violation there. Your bond will then remain at $4,000 cash.
Quick. Bill, call up Judge Fleischer. We got a live one here.
Do you have any questions, sir?
No, ma'am.
All right, that is all for today. Just push the button and let them know we're finished for today, if you would.
Okay, thank you.
You're welcome. Could you please state your name for the record?
Ernest Brown, Jr.
I'm sorry, what's your name?
Ernest Brown, Jr.
Okay, this is 54 DO2 2603 MC 629, State of Indiana versus Ernest Nathaniel Brown Jr. The record should reflect the defendant appears in the custody of the Montgomery County Jail by video. The state appears by Deputy Prosecutor Greg Miller. The Public Defender's Office appears by Chief Deputy Public Defender John Dreyer. Their office has not been appointed to represent you with respect to any charges which might be filed. He is here today to assist you with this detention hearing. The purpose of today's hearing is to determine whether you should continue to be held pending the posting of your bond or if you should be released with conditions. Do you understand, sir, what we're doing here today?
Yes, ma'am.
Thank you. Has counsel both received the pretrial services report on this case?
Martha, thank you so much for the gifted memberships. I appreciate it. Thank you.
Yeah, sure.
Yes, Your Honor.
State.
Your Honor, Mr. Brown admittedly has no FTA history, has no previous pretrial supervision violations. He is apparently a Louisiana resident. He is on probation in 2 causes out of Louisiana. He is employed. He's got a high school diploma. He does score low on IRAS, but he has a significant adult criminal history, including apparently aggravated kidnapping, carrying of illegally carrying firearms, flight from an officer, aggravated flight from an officer, burglary, and evading arrest detention. For those reasons, the state requests that Mr. Brown be held in bond.
Thank you. Mr. Dreyer?
Thanks, Your Honor. In looking at Mr. Brown's report prepared by probation, I have no disagreement with Mr. Miller about his failure to appear history, none. Previous supervision violations, none. And his IRAS is low. As to his past criminal history, the aggravated kidnapping, at least the information that I have from probation, it just shows count 1 of aggravated kidnapping, no further information available. So I don't know if that was dismissed. I don't know if he was convicted.
That was I think that was dismissed. I never had a court date on that charge. Like I had got that charge when I was in high school and never had court for it. It just always showed on my record. I don't know why. I had talked to my lawyer about it.
Good. All right. Thank you.
Shut up.
Yes, sir.
In terms of, okay, so we got failed to stop. Police command sounds like a resisting arrest. Probation reports that he was found guilty in March 23. The next offense from Calcasieu County in Louisiana, 4 counts, there's no further information available. So there's no indication that the case was not dismissed or whether there was any guilty finding in that. If we skip down to the 4-count offense, disposition date February 3, 2025, guilty to count 2. I think Mr. Miller mentioned that flight from an officer. We don't know.
The aggravated flight from an officer.
I'm going to guess since it's suspended 2 years, maybe that's a felony. And then we've got, if we go down below, guilty count 2, unauthorized use of a movable. I haven't any idea what that might be. sentenced to 5 years DOC suspended.
Sounds to me like it's probably an auto theft related charge.
Yeah, but I don't think it is. Only because my sister, she has probably 30 charges of immovable on her record, and that's all just burglaries. It's not. She does have an auto theft on her record. I turned her in for that, but that one doesn't say movable. But the other ones do, and I know that they were home burglaries. But I'm not saying, and store, and he was stealing. She was stealing from stores too, not just home burglaries. I'm not saying that this guy is a thief. I'm just telling you what I know of my sister.
Yeah, maybe. And then nothing for the charges below that, in which the offense is indicated 12-9 of 25. If I may ask Mr. Brown a couple questions, please, Your Honor.
Sure, Mr. Brown, if you could raise your right hand to be sworn, we'll take some evidence from you. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You put your hand down. Please state your name again for the record.
Ernest Brown.
Thank you. Mr. Dry?
Thanks, Your Honor. Good morning, Mr. Brown.
Good morning.
John Dreyer, as the judge said, I'm from the Public Defender's Office. I'm here just for the purposes of this hearing this morning. So you live in Lake Charles, Louisiana, is that correct?
Yes, sir.
Do you have any friends or relatives in this area?
No, sir.
And you live with your mother?
Yes, sir.
What's her name?
Jasmine Pucci,
And you're what, 22?
21.
21.
Yes, sir.
And if
Just a baby.
released, whether by payment of bond or if the judge releases you on your own recognizance, would you promise to appear at all future court dates?
Yes, sir. I show up to all my court dates.
And do you have a vehicle, or how would you get up here?
Someone told me about Zoom, but I got a vehicle. I drive out here to go to court.
Okay, I
But
presume you would return to Lake Charles in
Sir, he's just going to pick up a vehicle off the street.
Louisiana?
Yes, sir.
No other questions, Aaron?
All right. We'll find that Mr. Brown is 21 years old, that this is now his 7th contact with the criminal justice system, that he does have prior convictions for unauthorized use of a movable, which sounds like an auto theft charge, an aggravated flight from an officer, which is resisting law enforcement, another failure to stop, which is resisting law enforcement, that he has no contacts with Indiana or with Montgomery County. And more importantly, probably that he's on probation for 2 cases out of Louisiana, and it appears that he has other charges pending in Texas.
Uh,
Mr. Brown, you have a case of reckless driving and evading arrest or detention in Texas with no further information available that was filed December 9th.
yes, ma'am.
Court will find that Mr. Brown should be placed on a 15-day hold to allow Louisiana to file whatever paperwork they're going to file with respect to the probation violation. Then your bond remains $4,000 cash.
So after 15 days, I can have bond?
Yes, your bond will be $4,000 after 15 days.
Yes, ma'am. And so Louisiana, I don't have to wait to be extradited for Louisiana?
Well, that's what the 15 days are for, to see if they're going to file anything.
All right, yes, ma'am. And I got one more question. With the release of me being out of Montgomery, will I be on like any ankle monitor or something?
As a condition of our release?
Yes, ma'am.
No, but you will not be permitted to leave the state of Indiana without the court's permission. So if you post your bond, you can't leave the state of Indiana until you get permission of the court.
Oh, so if I was to get released, I have to sleep at a hotel until y'all give me permission to leave?
Correct.
Yes, ma'am.
Any other questions, sir?
No, ma'am.
Anything further from either side?
No, Your Honor. Thank you.
That's all for today. Thank you.
Thanks.
They're so young today. So young.
Good morning. Could you state your name for the record, please?
Jacoby Arsenal.
This is 54 DO2 2603 MC 630, State of Indiana versus Jacoby Arsenault. The record should reflect the defendant appears in the custody of the Montgomery County Jail by video for a detention hearing. The state appears by Deputy Prosecutor Greg Miller. Public Defender's Office is represented by Chief Deputy Public Defender John Dreyer. He's here to assist you with this detention hearing. Their office has not been appointed to represent you with respect to any charges which have been filed. The purpose of today's hearing, sir, is to determine whether you should continue to be held pending the posting of your bond or if you should be released with conditions. Do you understand the purpose of today's proceedings?
Yes, ma'am.
Thank you. Has counsel both received a pretrial services report in this case?
Yes, Your Honor.
Thank you, State.
Your Honor, the state is requesting that Mr. Arsenault be held to bond. The rationale is he has an active warrant out of his home state of Texas, out of Harris County, Texas, for unlawful possession of a firearm by a felon.
Just so you all remember, we are way up in Indiana, nowhere near Texas, but I guess that's where Texas people go when they're on the run.
He has, in his short 23 years, accumulated no less than half a dozen felony convictions, the most significant of which was out of Baldwin County, Georgia, where he was sentenced on count 3 to 20 years probation. Really don't need to go into any other detail as far as the state's concerned. Mr. Arsenault should be held to bond.
Thank you. Mr. Turner?
May I ask some questions,
You
Mr.
may.
Harrison?
Sir, if you'd raise your right hand to be sworn, we'll take some evidence from you. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may put your hand down. Please say your name for the record.
Jacoby Arsenault.
Thank you, Mr. Dry.
Thanks, John. Mr. Arsenault, I'm John Dreyer from the Public Defender's Office, here for the limited purpose of helping you along with this hearing. If you bond out or if the judge releases you from our jail, would you return to Houston, Texas?
Yes, sir.
And who lives there with you?
My mom.
And you have 3 younger siblings, is that correct?
Yes, sir.
And they're under 18?
Yes, sir.
Do you have any children?
No, sir.
You have a job?
No, sir.
Do you have means by which you can get back up here for any future hearings?
Yes, sir.
And do you pledge that you would attend all future hearings?
Yes, sir.
Do you have any friends or relatives in this area?
No, sir.
And you understand that if you post bond, you can only leave the state with the judge's permission?
Yes, sir.
No other questions?
Thank you. The court will find that Mr. Arsenault is presently 24 years old. Are you 24, sir?
23 years old, miss.
I'm sorry, 23 years old. That he has 1, 2, 3, 4, 5, 6 prior convictions plus a warrant that, as the state pointed out, he's on a 20-year probation term for one of his most recent convictions. That he has been convicted of burglary, theft, evading arrest, possession of marijuana, failure to identify, willful obstruction of law enforcement, 2 counts of theft by taking as felonies, possession of tools for the commission of a crime as a felony, criminal damage to property as a felony, and he's currently wanted on a warrant for possession of a firearm by a convicted felon. That he has convictions in multiple jurisdictions, or strike that, yes, in multiple jurisdictions of Texas, plus in the state of Georgia, and now he's facing felony charges in Indiana. Although he appears to have no contacts with either Indiana or Montgomery County, the allegations are that he participated with a group of young men to steal from an ATM at one of our banks here, causing a significant amount of damage. And as stated, he's on probation currently in 2 other cases. We'll find that Mr. Arsenault should be held for 15 days without bond to allow Texas to file whatever paperwork they're going to file with respect to any probation violations, or to increase this warrant to an extraditable warrant. At the end of 15 days, Mr. Arsenault, you'll have a bond available to you in the amount of $4,000 cash.
Yes, ma'am.
One of your terms of bond will be that you're not permitted to leave the state of Indiana without permission of the court.
All right.
Do you have any questions, sir?
No, ma'am. Thank you, though.
You're welcome. Anything further from your side? All
No, Your Honor. Thank you, Your Honor.
right, that's all for today. Thank you, sir.
All right, thank you.
You're welcome. Mr. Coons, do you have any questions?
Oh, I thought I was doing a plea agreement today.
No, sir. We're not doing a plea agreement. We will never do that by video. You would be here in person.
Okay, because I already met with his investigator, the lady, the Christie, about the video cam and stuff. She come out here one morning, and I told her I didn't need to know because I knew I was guilty, and we had.
So, well, hey, did you sign the plea agreement that was sent to you, Ernest?
Yeah, I've got the second one you sent me back right in my hand. Yeah.
Okay, I'll put it on my list to come get it.
Okay.
Judge, if you don't mind. When the jail officers come to you and say your lawyer's here to pick something up, give it to them at that time, okay?
Okay, I think I understand. You say when they come to say what? When the lawyer's here to see you?
Yeah, when the jail officers come and say your lawyer's here to pick something up, give them your signed plea agreement, would you?
All right. Okay. All right. Gotcha. Yeah.
Okay, I'll be over there tomorrow.
Okay, the first one I had signed, but then you said we talked about me just doing my time in jail.
Yeah.
Okay, all right, okay. Yes, I understand, and Your Honor.
Okay.
Yeah.
Okay. Anything further?
The sentencing is going to be when? May something?
We could probably just keep that jury trial date.
Well, I've already filled it all out.
Oh, did you? Okay.
Yeah. Mr. Coons, what?
You can, Kelly. Just stop buying coffee. Pull yourself up by the bootstraps and DoorDash. Then you can afford a swear jar like me.
All we've done here today is to continue your case, but once we get your plea agreement, we'll get you in within 30 days.
Oh, okay, okay. All right. Thank you.
All right. You're welcome. Any other questions?
No.
Okay, that's all for today. Thank you.
Okay, thank you.
Let me just see who you have here in person. Shirley Bird? Yeah. Come on up.
Your Honor, can I go up there with her? She don't understand this very good.
No, sir. Are you an attorney?
Going to be not here to meet the show.
You got Doctor. Doctor, you got a membership. Zach, thank you so much. Zach, tell me when you get to PA or what day you plan on going. I'll get you free tickets. I'll get you 2 tickets.
Sir, sit down.
Or there's
There's already a not guilty plea on for her. You are not an attorney, so you are not giving her legal advice. It doesn't matter. You're not going to sit up here and give her legal advice. You're not an attorney.
Just let her know what to do.
Well, there's already a not guilty plea on for her. It's already been taken care of, sir.
Yeah.
Can you state your name for the record, please?
Charlie Stockdale.
Mr. Stockdale, wait just a second. We have a hearing here in the courtroom. This is 54 DO1 2503 F6876, State of Indiana versus Shirley Bird. The record to reflect the defendant appears here in person and with counsel John Dreyer. What's the status of this case?
Your Honor, we don't have a good address for Mrs. Bird. So I'd like to meet with you when I get a break. And I want to get your current contact because I sent you a proposed plea agreement in January and all our mail was coming in.
Okay.
Okay. Can you do that, sir? Can we meet with it?
I can't hear you, sir.
Judge,
No, we are not having a conversation. This is a hearing. Please stop talking. Ms. Bird, what is your address?
It's 967.
47967?
Yes.
Do you have an email address?
No.
Your phone number? If you and your husband want to hang around a bit, I've got that plea. We can go to my office and I'll sure get some discussion.
Okay. So Ms. Bird, you need to be in touch with Mr. Dreyer so he can represent you in this case.
Okay.
All right, he's well versed in the law. He's a good defense attorney, so you need to talk with him about what the status of the case is. If you have witnesses or evidence that he needs to know about, he's the person that needs to know those things.
Okay.
All right?
Would the court please, bump out the jury trial of April 21st, Your Honor?
Any objections to that state?
No objection, Your Honor.
We will show on defense motion that the matter is continued for a status hearing on May 26th at 9 a.m. for a jury trial setting July 28th at 8:30 a.m. Absent further order from the court, that's when you're ordered to be back. Mr. Dyer is going to give you those dates in writing. Do you have any questions, ma'am?
No.
Anything further, Mr. Dyer?
No, thanks, Your.
State?
Nothing else, Your
All
Honor.
right, that's all for today. Thank you.
So it looks like, Zach, they might be going from Indiana judge to Indiana judge and upgrading their cameras to this one, which this courtroom was crystal clear. They just did it to Judge Maria Granger, and we could barely hear her before, and now we just really can't hear her. It's really bad. I don't know. Monica, thank you so much. Come back in. I'm just looking to see who Monica got real quick, and then we're gonna put on Judge Fleischer. You got Lori. Lori, you got a membership. All right, I need to pay attention to what I'm supposed to do. This was from a couple days ago. Obviously, it's Sunday, so it wasn't from today.
For telling me. All right, let's roll, nerds.
Just bottom of page 4, Falcon.
Now, most of you would have already seen this entire docket on Bill's channel. I know this. This is just inferior T-Move Judge Fleischer. I just take a couple clips and string them together. Bill gives you Walmart Judge Fleischer, the entire docket for a cheap price. That's what Bill gives you. So next time, next time you go on Bill's stream, pay him.
Hi, good morning. Mr. Falcon, your charge is failure to identify oneself as a fugitive from justice. That makes it a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On February 10th, 2026, officer in Harris County, Texas, observed defendant's motor vehicle traveling above the school zone limit of 20 miles per hour. Defendant was traveling 45 miles per hour in a 20 mile per hour zone with defective brake lamps. A traffic stop was conducted. Defendant advised he did not have his Texas driver's license on him, but gave officer a name and date of birth and was returned for a warrant out for his arrest. Officer placed defendant into custody where he stated, I may have given you the wrong name. I was just scared, and provided his real name and date of birth.
So what name did he give initially?
He gave the name Oscar Cobb.
Got it. Okay. What does he have open? Do you know?
So, running his history right now.
Does he have anything else that's open?
So I currently show no open warrants. I'm running his NCIC right now.
Okay. Perhaps it was traffic. Mr. Falcon, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to drive unless you have a valid Texas driver license and liability insurance in your name. You must maintain liability insurance. If you don't have it, then likewise, no driving. Do you understand? I don't care what you have to do in this life. If you don't have a license, do not drive. I'm not going to warn you again.
Your Honor, I don't see an open case aside from.
No. And then does he have a license to drive? Do you see?
I'm running his license.
Please. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with counsel, and she'll tell you if and when you have to come back to court. If she tells you she cannot get a hold of you, then likewise, you will go to jail. Looks like you had a case in Brazoria County. Is that still open or?
It is not, Judge. It was a,
It doesn't matter. I mean, just
it's taken care of now.
got it. Did you represent him on that?
I believe we did.
Yeah, okay.
Well, not the original case, but yes.
The stuff.
His license is not eligible, Your Honor.
Okay, you're not allowed to drive. You're going to be signing an affidavit with me today promising you're not going to drive. Like I said, I don't care that you have to go to work. I don't care that a kid has to go to the hospital. I don't care that you need food. If you drive, I'm going to put you in jail and no more PR bonds. Do you understand me? All right. We're going to have you come sign this, and after that, we'll get you out of here. We need you to sign more bond conditions, and after that, you'll get out of here. All right. Come on.
All right, Judge, next is top of 16. Chauncey Barrows, Ponce.
What page, Victoria?
Top of 16.
16. Okay, then. Oh, and I have Herman here online as well. So, Herman, I'll hit you up next. Good morning, Mr. Ontiveros. You speak English?
Speak up.
Sir.
Good morning.
Good morning, sir. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. Good morning, Mr.
Good morning.
On March 5th, 2026, in Harris County, Texas, officer observed a vehicle fail to stop at a designated stopping point at the intersection of 13th Street and East Boulevard by passing over the marked stop line before stopping at a red light. The vehicle also conducted a wide right turn and failed to maintain a single lane. A traffic stop was conducted. The driver and sole occupant was identified as defendant. Officer observed red bloodshot eyes, droopy eyelids, thick slurred speech, and a strong odor of alcoholic beverage emitting from defendant. Defendant stated he left a sports bar and that he consumed 4 Modelo beers. Standard field sobriety tests were conducted, 6 out of 6 HGN, 6 out of 8 walk-in turn, and 2 out of 4 one-leg stand. The IC was read and defendant refused to provide a sample. A blood warrant was executed and the blood was drawn.
The stop was for what?
He failed to stop at a designated stop.
Okay, so stop sign. All right, got it. All right,
It
Mr.
was a red light.
Oh, it was a red light.
He stopped over the line.
Oh, the white line?
Yes, and then
Got
maybe a wide right turn.
Okay. I just look at it and tell me if you see something different.
I will.
Come back and let me know.
Yeah, they
I'm
state that he
just get it.
stopped,
And
Okay.
let me know.
Yeah.
You know, I mean, any priority to be licensed, does he have a license?
No prize, Your Honor, his license is eligible.
Okay. For now, Mr. Ontiveros, I'm going to find that there's sufficient probable cause to go forward with your case as a condition of your bond. You're ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. No more PR bonds. Do you understand, sir?
He has a cash bond, Judge. He wasn't on a PR bond.
Doesn't matter.
Okay.
Yeah, just don't drink, don't use illegal drugs, don't drive unless you have a license and insurance. I'm not asking for much. Do you understand? Because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court. Just stay in touch with them. They'll tell you if and when you have to come back to court. For now, we'll have you just sign a reset. You'll get with, reach out for your bond conditions and free to go.
Thank you, Judge.
Come on.
Thank you.
Got it.
Any excuse?
Yes, sir.
Have a great day.
You too.
Yes, Herman has page 22 and 23. Ventura.
Good morning, Your Honor.
Herman, say something.
Yes,
Make sure-
sir. I'm here.
Deputy, do you mind hitting on the sound bar? There's a button on the other side, just right in the middle. Just if you want to hit it one time, please.
Yes, sir.
Herman.
Yes, sir.
No, one more time. Just hit it one time. Say something.
Yes, sir. I'm here.
There we go.
Yes, sir.
Okay, thank you so much. All right, you are Mr. Ventura. Sir, you're charged with 2 cases. You're charged with driving while intoxicated and unlawful carrying of a weapon. On the DWI, you're facing up to 6 months in jail and or a $2,000 fine, and on the gun case, up to a year. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. As you see, you are not here alone. If you look on the TV, your lawyer's here with you. Okay.
On March 8th, 2026, in Harris County, Texas, officer was dispatched to a traffic hazard call at 9900 Center Parkway. Officer stated that defendant was a sole occupant of the vehicle and asleep behind the wheel. The vehicle was in a moving lane of traffic, and officer observed defendant to have bloodshot eyes, slurred speech, and vomit on his shirt. Defendant admitted defendant was coming from his cousin's house and stated he was driving home. Steering wheel sobriety test were conducted, 6 out of 6 HGN, 2 out of 8 walking turn, and 2 out of 4 one-leg stand. DIC was read and defendant provided a breath sample. Results were 0.149 and 0.142. Officer recovered a firearm from the glove compartment of the vehicle and 2 magazines in a center console.
Would you say the stop was that zoned out?
So the officer was dispatched to a traffic hazard call, and the defendant was stopped in a moving lane of traffic.
Got it. Okay.
Your Honor,
Sure.
I didn't hear anything that indicated that when Mr. Ventura was operating a vehicle, he was intoxicated. The engine was off, and they don't do anything to pinpoint when he was operating the vehicle. There's no witnesses of
In a
him
moving lane
operating
of traffic.
with the
it
engine off.
stopped and he's alone.
He stated that he was driving to Your Honor.
Oh. Did you hear that, Herman?
I did not.
He stated he was coming from his cousin's house and driving home.
Okay, but it still doesn't pinpoint the time. He could have been sitting there for an hour, and they don't know what time he was operating. There's no evidence of him operating at a time where he's intoxicated.
Okay. Well, I mean, I think that there's enough to go forward, Herman.
Fair.
Sorry.
Fair.
Mr. Ventura, I'm going to find that there's probable cause to go forward with your case, and I am now ordering you, and I'm placing now a restriction on your license. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If I find that you drive a vehicle that doesn't have an interlock, I will revoke your bond and put you in jail. Do you understand? No.
Judge.
No.
May I address that? I thought he was under 1.5 without an accident.
He has a prior DWI from 2.5 years ago. He's got vomit
Fair.
all over himself.
Okay.
You know, he's passed out. You're going to get an interlock if you don't drive
Okay.
without one. I only have one place for you. Do you understand me? I'm not here to play the games. I'm here to protect my community. I'll do it at all costs. And if I have to throw your ass in there for a long time, you and only you hold the keys to the cell. I'm not asking much. I just don't want you to consume alcohol, no illegal drugs, and don't drive without an interlock. Do you understand? I'm not asking you to reinvent the wheel. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Herman, and he'll tell you if and when you have to come back to court. If he tells me he cannot get a hold of you because you're ducking and dodging, likewise, he'll warrant issues. This is not a revolving door. If I have to put you in jail, I'm going to revoke it and I will make it high. Do you understand? Does he have a license to drive?
He does, Your Honor. I would let Farwell confirm that it's eligible, but we've done the ALR.
Okay.
Yes, Your Honor, I'm running the license number right now.
Okay. One more thing. If you are to drive, you must maintain liability insurance in your name. That is also a condition of your bond. If you don't have car insurance, then no driving until you do. Do you understand? All right. We'll have you sign a reset. You'll get pre-chop for your bond conditions. After that, you'll be free to go.
All right, Judge, age 12 through the 14th.
Oh my God, that was an angel. Did you hear that, angel? Judge A12 through the 14th? That was, who are you today? Lint Liquor 3000. We got Victoria here from Judge Fleischer's courtroom. Yes, we do. Be nice to her. Well, you don't have to. She will destroy you if you don't. I'm very terrified of her, but I'm totally obsessed with her as well.
Did you hear that, Herman?
I'm sorry. No, I didn't know that was going to be my, what is it?
May 12th through the 14th.
No, let Victoria say
I'll take the 13th, Your Honor.
Rude.
Okay. And then can you file the interlock paperwork?
It's there,
It's in there? Okay, great.
Thank you, Your Honor. Have a good
Okay,
weekend.
thanks,
everyone.
Herman. Have fun.
His license is eligible, Your Honor.
Great.
All right, Judge, top of page 1, Acosta.
Mr. Acosta, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 5th, 2026, officers received information of a parking lot takeover. Officers observed a motor vehicle perform 3 donut burnouts within 15 feet of several motor vehicles and bystanders. A traffic stop was conducted and defendant was identified and admitted to doing the donuts.
Do they have a license to drive?
But we do not have a license.
Mr. Acosta, I'm going to have you sign an affidavit with me today promising me you're not going to drive. If I find that you do, I can have a contempt hearing, and every time you drive, you can be facing 180 days in jail and a $500 fine. I don't know why you're smirking and laughing. This is your second reckless driving within a year. If I find that you endanger my community, I'm going to lock you up and I'm going to make your bond high. You were ordered not to consume alcohol or illegal drugs, and I'm going to test you like crazy to make sure you're not using. Test next week, please.
Tell us, Bill. Tell us the secret. Please. Please. Oh my God.
You will be
pregnant?
tested for drugs and alcohol, illegal drugs.
Are you going to be a mommy again? Tell that man to get off of you.
And alcohol. If I find out you're using, likewise, you will go to jail. No more PR bonds for you. You will be signing this affidavit promising me that you're not going to drive. I don't care what you have to do in this life. Do you understand, Mr. Acosta? Come up here. We'll have you sign it. I'm going to reset your case to give you time to hire a lawyer, and then we'll have you meet with pretrial.
All right, Judge, bottom of 2, Bishop. Please,
Did they confiscate the car?
I can check it, Your Honor.
They never confiscate the car. They never do. The judge keeps saying that they have these new rules that they could take the car. I'm waiting to hear someone who got their car taken away. They didn't.
I have to check the basketball. I don't see any of it.
No. Ma'am, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On March 8th, 2026, officer checked by on a crash in Harris County, Texas in regards to DWI investigation. Officer advised that upon arrival, defendant was standing outside her vehicle, keys on her hip. Defendant stated the crash was her fault. She lost control of the vehicle and struck another vehicle and hit the walls on the side of the freeway. Officers observed the strong odor of alcoholic beverage and red glossy eyes, and defendant advised she consumed 4 shots of tequila. Standard field sobriety tests were conducted, 6 out of 6 HGN, 1 out of 8 walking turn, and 3 out of 4 one-leg stand. DIC was read and defendant provided a breath sample. Results were 0.142 and 0.144.
Any prior DWIs?
No prior DWIs, Your Honor.
License?
Eligible.
Ms. Bishop on.
You hear that, Brad? You're on a liquid diet. That includes tequila. Just saying, you can drink tequila right now. I actually suggest it. I suggest you drink tequila. So your doctor might have said no alcohol, but did they specifically say no tequila? Don't drink the worm though. That's not liquid. Happy birthday tomorrow, Kay. I hope you have a great birthday.
Find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, you will go to jail. I will revoke your bond. You understand? Yes or no?
Yes, sir.
You are not allowed to drive unless you have a valid license, and you must maintain liability insurance. If you don't, then likewise, no driving. You have the ability to hire a lawyer.
Yes, sir.
Okay, we'll give you time. I'll have you go to Victoria, sign a reset. You'll go pre-trial for your bond conditions, and after that, you'll be free to go. There's a lot of timing requirements with the DWI. Don't wait a month. Don't wait 2 months. You need to get on it quick. All right? Okay, please.
All right, Judge, counsel's approaching for top of 17. Reyes, come on up.
Judge, I also have Marcus Spears, and I don't know if you want to do both.
Sure.
Okay.
Let's do
What's the
it.
other one?
Spears. Marcus?
Kelly Newell's son is streaming on Twitch right now, guys. I just sent you the link. Zombie Parkour.
It's what I gotta do.
I don't know if you can. I don't know if you can hear my twitch in my, but
So the first one was top of page 14,
Top of 17?
17. Got it. Okay. And then the other one was which one?
Spears.
Spears. Just last name, please,
Page
Franz.
20. Like, Spears.
it's Brittany. Never mind.
Good morning. Each of you are charged with driving while intoxicated. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Ms. Reyes, yours is elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. Sir, you're facing up to 6 months in jail and or a $2,000 fine. Okay.
For Ms. Reyes, Your Honor, on or about March 7, 2026 in Harris County, Texas, officer assisted other officers on a major crash on Gold Freeway. Defendant was driving one of the vehicles. Witness observed defendant driving the vehicle on Gold Freeway on the shoulder at a high rate of speed, almost striking his vehicle. Witness observed defendant lose control of the vehicle and crash into another vehicle. Witness stated that the defendant said she was trying to have fun and didn't mean to hurt anybody. Witness 2.
So what, like a demolition derby?
Yes, Your Honor. Witness 2, the driver of the vehicle that was struck, stated she was all of a sudden struck by defendant's vehicle. Defendant was detained for being non-compliant during a crash investigation and stated she was coming from a friend's house where she was playing drinking games and that she consumed 3 to 4 margaritas in total. She also stated she took Adderall medication that day at 12 p.m. Officer observed defendant to have high emotion, bright glossy eyes, the odor of alcoholic beverage, poor balance, and slurred speech. Standard field sobriety tests were conducted, 6 out of 6 HGN, 7 out of 8 walk and turn, and 4 out of 4 one-leg stand. PIC was read and defendant provided a breath sample. Results were 0.167 and 163.
Okay. Any prior DWIs?
No prior, Your Honor.
Any prior contact with the law whatsoever?
I got no criminal history.
No. Okay. If you want to go ahead and, the gentleman.
On March 7, 2026 in Harris County, Texas, officer was dispatched to a traffic hazard on FM 1960 Road. Officer observed defendant sitting in the driver's seat and defendant to have strong odor of alcoholic beverage on his breath, red bloodshot eyes, and slow slurred speech. Defendant stated he was coming from a bar in Brill and that he had two drinks. Standard field sobriety tests were conducted, 6 out of 6 HGN, 5 out of 8 walk and turn, and 4 out of 4 one-leg stand. PIP was read and defendant provided a breath sample. Results were 0.142 and 144.
Did you tell me if Ms. Reyes has a license or no?
She does, Your Honor, and it's eligible.
And on Mr. Spears?
Mr. Spears is.
And any prior DWIs?
His license is eligible and no
Great.
prior DWI.
Okay.
And Ms. Reyes does not have a vehicle, so.
I'm ordering her to obtain a portable device.
Yes, sir.
Ms. Reyes, I'm going to find that on each of you, I'm going to find that there's probable cause to go forward with your case. Both of you are ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using anything that's illegal, you will go to jail. That includes controlled substances, marijuana, anything. If you use, you go to jail. And I don't care what your excuse is. You, ma'am, I am now ordering you to obtain a portable device, and I'm ordering you not to drive any vehicle that doesn't have an interlock on it. I don't care what's going on in your life. I don't care what you need to do. I don't care where you got to go. I don't care if you need groceries. If you don't have an interlock on a car, you are not allowed to drive. Do you understand? I'm sending notice to DPS so that every police officer in the state knows if they pull you over, the car that you're driving doesn't have an interlock, they will take you to jail. You will get a portable device now, so proving to us that you're not going to consume alcohol. Do you understand? Because both of you have lawyers, I will waive your appearance. It is your responsibility to stay in touch with him, and he'll tell you if and when you have to come back to court. If he tells me that he cannot get a hold of you because you guys are playing games, if you pick up a new charge, if you are a danger to my community, I'm going to revoke your bond and I will put you in jail. No more PR bonds. Do you, each of you understand? All right. You'll get to Victoria, sign a reset. You'll get with pre-chop for your bond conditions, and after that, you're free to go.
Thank you, Your Honor. Maybe
Please. Yes, sir.
All right, Judge, top of 3, Bowen.
And I have these.
I might pay for a little bit of that, Victoria. How much is it?
He's waiting for him. Maybe we'll see.
Last name, sir?
Alpha 3.
Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Officer spoke with complainant and stated that on September 14th, 2025, at 3050 Almeida Genoa Road in Harris County, Texas, her ex-boyfriend defendant assaulted her. Complainant stated that she and defendant dated for a year and that on September 14th, she was driving westbound on Almeida Genoa from Colon and that defendant threw a drink in her face and was pulling her hair while she was driving. Complainant had to pull over into a dollar store nearby due to her not being able to drive while her hair was being pulled. Complainant stated they both got out of the vehicle and she told defendant to stop. Both parties then got back into the vehicle and continued. Complainant stated she got on the 288 when defendant started to pull her hair and punch her in the face with a closed fist. Complainant stated she bit defendant's finger while trying to defend herself and pulled over again. Complainant stated they both got out of the vehicle. The defendant was in her face, calling her a bitch. Defendant then headbutted the complainant in the forehead. Complainant pushed defendant and got into the vehicle to leave. Complainant made it home before calling the police.
I apologize for the very vulgar language on this stream.
While speaking to the police, complainant noted that defendant was nearby because watching him. Sorry, Your Honor. Defendant was nearby watching due to him calling and stating, "Why did you call the police?" Complainant went to the station the next morning to file a report and stated that the defendant pulled her hair and punched her in the face with a closed fist, causing her pain. Complainant provided pictures of false spots caused by defendant pulling her hair and a busted inner bottom lip. Complainant stated that on September 20th, she had another incident located near Cullinan Airport in southeast Harris County, Texas. The complainant stated defendant ran up to her and pinned her near her vehicle and stated she took his ring the day of the last assault.
So after the assault occurred, there's another contact?
Yes, Your Honor.
What day? Because he was under bond. So did he get arrested? Because he's under bond conditions. And if you're telling me that there's subsequent contact, I'm going to put him in jail.
The initial incident was on September 14th, and then the next incident was on September 12th. We can look at the response conditions, Your Honor. There was a Your Honor, it looks like the MOA and the bond petitions were not filed in front of me.
Mr. Bowens, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. You were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, you will go to jail. I'm ordering you to stay at least 2,000 feet away from this person. If you go anywhere near this person, I will revoke your bond and put you in jail. I'm going to put a monitor on your ankle so I know where you are at all times. And if you go anywhere near this person, you put hands on this person, anything, you will go to jail. I will deem you a public danger, and I'm going to make your bond extremely high. Do you understand? I'm going to protect my community at all costs. And there's nothing you can say at this point, but let me enlighten you on something. If I have to put you in there and make your bond $500,000, I will do it, and I won't lose a minute of sleep over it. You understand me? I don't care what is going on. I don't care what you need. I don't care if she's got Bambi in the house and you need it. You try to have any kind of contact, I'm going to lose it. Do you understand me? There is a protective order that has been issued in this case, and you need to get to know it. If you do something to violate this protective order, the state can and probably will file a violation of a protective order, and that is the capital murder of misdemeanors. Do you understand? No contact means no contact at all. I don't care who initiates it. I don't care if she calls you. I don't care if if she texts you, comes to your house, no contact means no contact at all. If she calls you, hang up the phone. If she texts you, do not reply. She comes to your house, do not answer the door. You are the one that will go to jail. Do you understand? We are going to reset your case to give you time to hire a lawyer. I will have you go to Victoria Center Reset. You'll reach out for your bond conditions, and then we'll have you take a seat while we get all the paperwork.
If I was her, I would disguise myself as Publishers Clearinghouse. He'll let her in.
And after that, you're free to go. Come on. Yeah, it was a 2B at the time, so, right. He wasn't under bond condition at the time, so. Hey,
Just briefly on Spears and Reyes. Spears, I know he has no travel restrictions. He just wanted to let the court know he does have plans to go out of the country next week. I told him he needs to check in with pretrial.
how long is he going and
I
where?
think 5 days.
Okay,
Into where? The minute.
okay, he's not allowed to use. He's gonna get tested. When it gets back, let him know we have tests that go back a couple of weeks. So if we find out he's using, then he's gonna go.
Okay,
Yeah.
sounds good, Judge. And then, Ms. Reyes, she says that she was going to try and get a rental car next week.
Whatever car she's driving, she needs an interlock on it.
If it is a rental car, there's no way we can get a.
Then she's not driving. I don't care.
Okay,
I want her, she's gotta have an interlock.
Okay, understood, Judge. Thanks.
Okay, all
Appreciate
right.
it.
Sorry, Rex. Hey, hey, sure. No, can we do, please? We've got a ton of stuff. And then I've got an Chinese, I've got the interpreter.
And council's not here yet.
Yeah, please just.
Council, Evans is.
Yeah, Evans is here.
12, Lamont. Come on up.
Hey, Colin. So, Miss Woe, we're waiting on the defense counsel. As soon as they get here, I'll let you know, okay?
Morning, Judge.
Hi, Colin.
THA?
THA, yeah.
All right, go ahead.
Did you see who this is? Starts with an L. Layman.
Layman.
Yeah. Good morning, sir. So, as you can see, your lawyer is here with you on Zoom. Sir, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Pulling it up right now, Your Honor. On March 6, 2026, officer in Harris County, Texas, observed a vehicle leave Little Woodrow's parking lot with no lights on. The vehicle did not have lights on when it made a left turn onto Washington Avenue, and the traffic stop was conducted. Defendant admitted that.
Wait. He left the parking lot at night without lights on?
Yes, I'm confirming the time, Your Honor. Yes, it was 1:30 a.m.
Okay.
A traffic stop was conducted on the vehicle and defendant admitting to having beers. Officer observed a strong odor of alcoholic beverage on defendant's breath and glossy eyes. The officers located empty beers under the motor vehicle.
There's beer in the vehicle?
Checking the DIM, Your Honor.
No, Judge. They're empty.
Yes, empty beers located behind the front passenger seat. Standard field sobriety tests were conducted. 6 out of 6 HGN, 1 out of 8 walking turn, and 0 out of 4 one leg stand. DIC was read, and the breath sample was refused. A blood search warrant was executed.
Your Honor, if I may.
Sure.
Glossy eyes are not a clue of intoxication. That was removed from the NHTSA SFST manual years ago. All they have at this point is my client leaving a bar parking lot. He had a brand new car that doesn't have the auto turn on for the lights. Apparently, that's a new thing that I've just learned. And he didn't manually turn it on. although it was 6 out of 6 HGN that the officer
But
claims.
that's not a justification for not, if you, regardless, if you're driving at night, you got to turn it on. You can't just rely on the car to turn it on for you.
Sure, and it was a new car, Judge. He wasn't used to it yet, and he was used to my car has the auto lights on, so I don't ever look down and mess with it. So, as far as the stop, the lights were off. The lights were off. I'm not arguing that there wasn't a reason for a stop, Judge, but I am arguing that there is no PC for an arrest for DWI. There are no other clues of intoxication. There was an odor of alcohol. He admitted to drinking, and that, as the court's well aware, that is not illegal.
He's coming from a bar. It's 1:30 at night. He's got beer in the car. He's got an odor of alcohol. He's got glossy eyes.
Glossy eyes are not a clue of intoxication, Your Honor.
Your Honor, he also admitted
That was, and that is not illegal. Drinking at a bar at night is not illegal, and driving after doing so is not illegal. He had one clue in the walk and turn and 0 clues on the one leg stand, Judge. There are no other clues that the officer notes as far as unsteady balance, having to use the car to balance or check his balance, anything like that. Nothing as far as
But he fails the HDN though.
And Judge, I've had Officer Roy in cases recently, and I haven't had a chance to look at the video yet, but I'd be willing to put money down that it wasn't administered correctly.
But I can't. I can't. It's not fair to the state to take.
It's also not fair to my client to be arrested for something that he didn't do. I mean, they didn't even reach the decision point. You've got to have 2 clues at a minimum on the walk and turn and the one leg stand to reach that decision point.
I believe there was enough to conduct a DWI investigation. The defendant admitted to drinking. He had a strong odor of alcohol.
I think that there's certainly enough to begin a DWI investigation. He's coming from a bar. It's 1:30 in the morning. He gets pulled over. He smells of alcohol. He's got beer in the car. Regardless whether it may be empty or not, I don't know. But I certainly think that that's sufficient to initiate an investigation. Does the HGN? He fails. He does pass the other 2 tests, but this is just for probable cause purposes.
Bill, Victoria, don't tell us the end. All right? We're just trying to figure this out.
I think there's enough for probable cause. There may be not enough for beyond a reasonable doubt, but I think that there's enough for probable cause. Mr. Lehman.
I think that there's.
I think we have the walk and turn, Bren, purely for comedy value. I think that's why we have it. Lifting the leg off the ground, pure comedy. I think that's why they do it.
Go ahead.
Judge. I agree that there is enough for reasonable suspicion to conduct a DWI investigation, but at the conclusion of his DWI investigation, he did not have enough for probable cause, Judge.
He failed the field sobriety test. Granted,
that's assuming that the officer administered.
But okay, I'm going to find that there's enough for probable cause, Mr. Lehman. The only thing I'm asking you to do at this time is do not consume alcohol or illegal drugs. If I find that you do, I will revoke your bond and put you in jail. You're not allowed to drive unless you have a valid Texas driver license. You must also maintain liability insurance. If I find that you're driving without either, likewise, you will go to jail. Do not pick up any new cases.
Hi, Debbie.
A lot of this life is who you hang out with. If you hang out with the wrong people, they're not the ones that are on bond. You are. If they don't care. If they're doing something and you shouldn't be doing and you hang out with them, temptation's a bitch. You know what I mean? So be very careful. You ever have any issues, you got a great lawyer, talk to your lawyer. He can help you out, but there's just no excuse. You understand?
What a different world we live in, huh? Remember growing up? Everybody was drunk when they had beer openers, the bottle openers right there. There's your steering wheel. There's the bottle opener right next to the cigarette lighter.
All right. So for now, we'll just have you sign your bond conditions, and then after that, you're out of here. Let me have you go to Victoria. You'll sign a reset. You'll get with pre-trial your bond conditions.
Go ahead and sign.
You said May 14th-ish, right?
I already picked the date.
Oh, you
Yes,
did?
Judge.
All right.
All right, Judge. Ready for the next one?
You know, get a, call in if you want, get an expedite.
No, Victoria, he apparently is not ready for the next one. Knock it off. You're not a jailer. Let the man breathe. Actually, guys, if Victoria wouldn't keep things moving, we would still be on the first person in the docket. And they got an interpreter waiting, and they got all these people sitting there making noise. The elf is trying to calm down. Good job, Victoria.
Suppression hearing. I'm happy to do it.
Sure.
Okay.
Yeah, we'll consider that, Judge. And just to make sure, my client does live in Dallas, so if we can have this next appearance waived.
Yeah, of course. Yeah.
Thank you, Judge.
You got it. Okay, man. Thanks.
Take care. Have a good weekend.
You too, man. Take care.
Bye.
Right, Judge, top of 4.
She is the best. She is. No, Bobby, no.
Good morning, sir.
He needs to go faster.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Hey, deputy.
I'm sorry.
Can you move those two right there?
Oh, no, I gotta stop, and I have to. I can't let that go by in chat. Victoria is absolutely not a typical woman at all. She's far superior to us in almost every way. Almost. I'm not going to tell you what the almost is. Debbie, thank you so much. Thank you. And I'm not just saying that because I'm scared of her. She's going to beat me up. Because she will. He can breathe when the docket is over.
The gray sweater, they think it's the club, man. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 7th, 2026, in Harris County, Texas, officer observed defendant's motor vehicle strike.
Victoria is the woman behind the judge, back over there, saying, "All right, Judge, page 4, Burnett." And he says, "Burnett, get up here." "All right, Judge, you ready for the next one?" When he says counsel for a reset, you go over to Victoria. Not really. There's other people, but you go over to Victoria. She opens his mail so she could get really sick just protecting him. She's his little bodyguard. But yeah, I'm more scared of her than the bailiff. Just telling you that right now. I've been to his court twice. And I feel like I can take the bailiff, but Vicky, no. And she's also known as Lint Liquor 3000 in chat today. Tomorrow should be something else, don't worry.
Traffic controllable. Defendant, the driver, was detained. Officer observed strong odor of alcoholic beverage, watery red bloodshot eyes, unsteady walking, and poor balance. Defendant admitted to drinking 5 beers at the Houston Rodeo. Standard field sobriety tests were conducted. 6 out of 6 speech GN, 2 out of 8 walk and turn, and 2 out of 4 one-leg stands. DIC was read, and defendant refused to provide a sample. A blood search warrant was executed.
Okay. Any prior DWIs?
No prior DWIs, Your Honor.
License?
Eligible.
Okay. Sir, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, you will go to jail. I will revoke your bond. Do you understand?
Yes, sir.
You're not allowed to drive unless you have a valid license and insurance in your name. If you don't have it, then likewise, no driving. That is also a condition. We will have you sign a reset. We'll have you get with pre-trial for your bond conditions. Then after that, you'll be free to go. Okay? Please, when you come back, please have a lawyer.
They did take all my matches and lighters. All of them. Every one.
Good morning, ma'am. Ma'am, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On March 7th, 2026, officer in Harris County, Texas was dispatched to a disturbance call at La Micopana. Complainant advised that defendant purchased a beer, came back inside and started a verbal confrontation with an employee and complainant. Defendant approached her and hit her in the head multiple times with a beer can. Complainant advised she felt pain and swelling on her head.
So they're at a bar.
Yes, I believe so. It's a La Micopana, Your Honor.
Michoacán. Okay. Ms. Garcia, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You're also ordered not to have any contact with the complaining witness and not to go back to this establishment. I'm going to protect my community at all costs, Ms. Garcia. This is number 4 within 1 year. Number 4. I guess we are not getting your attention. Sometimes things may have to be more drastic.
You really want to teach her a lesson?
You
Make
are
her
not
feel your
allowed to be in
pain.
possession of any weapons as well. If I find that you're using any kind of alcohol or illegal drugs, then I'm telling you now, this is not a revolving door. You will go to jail and I'm going to make your bond high. With number 4 already within 1 year, if I have to revoke your bond and put you in jail, I'm telling you, it's going to be a high bond. Do you understand me? You have the ability to hire a lawyer, ma'am. Do you have the ability to hire a lawyer? How are you supporting yourself now?
Family friend, and work as well, and I'm a college student as well.
How do you,
I work for a call center for refund and
okay, is this a full-time job?
It's a full-time job.
Okay, you must maintain full-time employment or be in school full-time. Deputy will give you an application. We need you to fill it out. I need to know everything about you, and then we'll take a look and see whether you qualify. Come on.
All right, Judge, page 7, Gonzalez.
Say,
You're doing Gonzalez, come on up. Go ahead and start with the research, please.
Good morning, Mr. Gonzalez. Sir, you're charged with failure to stop and give information, leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
We forgot Victoria was here. Linus is in bed. She's very young. Victoria's like 32, 33. Victoria wins.
You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On February 5th, 2026, officers dispatched a hit and run call in Harris County, Texas. Complainant advised that he exited Circle K on Nassau Parkway and defendant exited a private driveway traveling the same direction, causing complainant to swerve. Defendant then positioned his motor vehicle alongside complainant's and struck his vehicle on the driver's side quarter panel door. After the collision, defendant made a U-turn and traveled eastbound. Complainant followed defendant to get a license plate and defendant stopped in the parking lot, exited the motor vehicle, and began yelling at complainant before driving off. The vehicle was located using flock camera footage, and defendant was identified by the complainant, who was shown an ID card photo.
Incognito, could you tell me how you found this stream? I'm dead curious.
So she's able to identify him.
Yes, Your Honor.
Okay. Does he have a license to drive?
Yes, Your Honor, it's eligible.
Okay. Mr. Gonzalez, I'm going to find that there's probable cause to go forward with your case. You are not allowed to drive unless you have liability insurance in your name, and that is a condition of your bond. If I find that you drive without it, I will revoke your bond and put you in jail. You understand? We are going to reset your case to give you time to hire a lawyer. I will have you go to Victoria Center Reset. I'm going to have you take a seat in the jury box while we get your bond conditions. Once you sign them, at that point, you'll be free to go. When you come back, please have a lawyer.
Your other state's bond condition?
Yeah, no driving without insurance and then a license. And no contact with a complaining witness.
Yes, Your Honor.
Oh, go ahead and sign, please. All right, Judge, next is bottom of page 8. 8 mirror.
I'm sorry, I missed a page, Vic.
Bottom of 8.
Damn, only 8? Good morning, ma'am.
Good morning.
Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On March 5th, 2026, in Harris County, Texas, officer was dispatched to a disturbance. Complainant advised defendant took his motor vehicle without permission. He called her to bring it back and she returned walking. Defendant began punching complainant in the face with a fist and scratching on his chest, causing complainant to bleed from the nose and have marks on his chest, ripping his shirt. Complainant advised he felt pain.
Got it. Okay. Ma'am, I'm going to
Older
find that
than
there's
what?
probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to have any contact with this person. There is a protective order that has been entered now. You need, hold on. It has not been entered. I'm now going to enter in what's called a magistrate's order for emergency protection that identifies.
When I drink alcohol, I get much younger.
Hey, Bernadette, on this, do you mind filing a new MOA? I think this one's wrong. Maybe that's why they didn't grant it. It's Ikmir.
I do not want to do my 20s and 30s over again. No, thank you. No. No, I did
I think
enjoy
it's
my
wrong.
40s though. That was a good time.
Ikmir.
IKEM, sorry.
No. Yeah, it's definitely wrong. Please. All right. So what I'm doing is I'm entering what's called a magistrate's order for emergency
All right,
protection.
Bobby.
That identifies.
Let's try this again, Bobby. We're going to do this again. Bobby, how many of each animal did Moses take on the ark?
Mr. Hurt, as a protected individual, you cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You can stalk, threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. If you violate this agreement, they can and probably will file a violation of a protective order against you. That is one of the worst misdemeanor cases you can pick up. So just no contact, no weapons. You understand, ma'am?
Yes, sir. I cannot.
Okay. Are you working at this time?
Yes, I'm working at this time.
Okay, so lawyers are based on need. You have to qualify for a court-appointed lawyer, meaning that you have to be at the federal poverty guideline. So that means you're making $15,800 a year. That's what qualifies for a court-appointed lawyer. I don't have an unlimited number.
Seems like a lot.
I can have you fill out an application, but if you're working and you make good money, your chances are you're probably not going to qualify.
The last vacation I took was 2018, and I went to Ireland. Oh, God. It was so good. Oh, so beautiful. I mean, I don't know how or why I came back to the United States. I just loved it. My favorite part was we went to this farm, this tiny little farm with 3 border collies and, you know, a bunch of sheep. And oh my gosh, the dogs with those sheep were amazing. If I could live on that farm for the rest of my life, I would be the happiest person in the world. The dogs were so, and then the beer. I mean, I had Guinness for breakfast, lunch, and dinner. Here's how I knew when it was breakfast and when it was dinner. My breakfast Guinness had currant in it, and then my dinner and the rest of the night Guinness in it. And I knew what time of the day it was. What? That was so good. Their dogs are so, I mean, Ireland is beautiful. It's just everywhere in Ireland is just breathtaking.
Don't.
I believe you, Ben. I believe Australia is beautiful,
This
but
is
I
a
don't know
sworn
if it's
document.
better.
You're going to swear to it, so everything
shit.
I need to know about you.
Hi, Drunken Smurf. I didn't mean to ignore you. I was lost in Ireland, and that it always takes me away.
How much money you have in the bank? How much money you have coming in? Are you married? Are you boyfriend? Do you have any other sources of income? What kind of car you have? And then I'll take a look to see whether you qualify. Okay? Please.
That's it? It's over already again? Jeez. It's been an hour and 45 minutes. It feels like the stream just started. This sucks. Alright, guys. What is today? Sunday. So, tomorrow, we can watch Bill. We can watch American Courts. We can see Judge Fleischer live. Yes, we can. We can hear Victoria live. And, you know, she'll walk in front of the camera every once in a while. Maybe. Who knows? Victoria, thank you for coming into our stream. Thank you for calling me. I needed you too. I got a great idea, guys, but I can't tell anybody about it. I had to make sure it was legal. Guys, I hope you have a great night. I'm going to be streaming again in another 6 hours, so... No, you weren't, Bill, you liar. Your nose is growing. You walk into a door with that nose. Bye, Drunken Smurf. It was good to see you. If I'm not asleep, I'll be there, Bill. But, you know, I might be asleep. I'll see y'all in a few hours. Behave, guys, alright? I'll see you soon. Thank you. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide.